Good afternoon, General Sumter.
After these years, it'd be Warner.
Good afternoon, everyone. This is Mia. Good afternoon, Mia.
Good afternoon.
Hello.
Hello.
Good afternoon. Good afternoon, everybody. We'll be starting in about 5 minutes. Hope that you had a great weekend.
Elliot, your views changed a lot.
Yeah, it's nice to see a different landscape. Jackie, it's Elliot. For this oral argument, were the attorneys told to wait? Or should they? Okay, they were not. Thanks.
I told them to click on the link at 1 o'clock.
Okay, thank you.
Good afternoon, everyone. I'd like to call the meeting to order. Ask everyone to mute their phones or their devices unless they're speaking. At this time, I'd like to turn to Dr. Simpson. Dr. Simpson, would you mind calling the roll? Thank you.
Good afternoon, everyone. Mr. Bartley. Mr. Bartley. Ms. Bates.
Present.
Hi, can you hear me?
Yes, I can hear you now. Thank you, Mr. Bartley. Mr. DeShiel.
Present.
Dr. Getty.
Present.
Dr. Green.
Present.
Ms. Hallie.
Present.
Dr. Lee. Dr. Lee. Ms. McCusker.
Present.
Dr. Lee McCarthy.
Present.
Ms. Morrow.
Present.
General Sumter.
Present.
Dr. Wilcox.
Present.
Mr. Wu.
Present. Good morning.
Good morning, Dr. Salmon.
Present. Hello, everyone.
Hello, and President Crawford.
Present.
The roll call is complete.
Thank you. Mr. Shaw?
You have 13 members present. Dr. Lee is absent right now.
Yes.
No quorum.
Thank you. Well, again, good afternoon, everyone. I'd like to welcome the board members, staff, members of the public to the meeting and to provide the remarks regarding the virtual meeting. Today's meeting will be conducted via live stream through the WebEx virtual meeting platform. The public can access the meeting from the state board's website. The meeting agenda and the materials are posted on the website. The archived video will also be posted on that website. During the meeting, only the board members, staff, and participants during the oral reply will be allowed to speak. Board members are asked to hold their questions until the end of the presentation, and board members, staff, and participants in the oral reply are asked to identify themselves when speaking. Again, welcome to everyone. And I would like to, at this point, turn to Mr. Schoen. Mr. Schoen, we'll turn this over to you to help tee up the oral argument.
Thank you, President Crawford, members of the board. I would like to announce the oral argument and the appeal of Laverne Largie Tucker et al. Versus the Howard County Board of Education. This is a redistricting case, and this is the exceptions hearing from the administrative law judge's decision affirming the decision of the Howard County Board of Education. This exceptions hearing involves 4 appeals. Abinash Dewani, David McCormick, and Jilly Tater, Chin-Li Shui, and Laverne Largie Tucker. At this time, I believe attorneys for both the appellants and the Board of Education are present. Counsel, starting with the appellants, would you introduce yourself to the board and for the record, please?
Good afternoon, board. My name is Lorraine Lawrence Whitaker, and I represent the appellants. That the person who was just announcing the case announced all of those people very well, by the way. There's hard names, some of them, but I represent all of the appellants.
Thank you very much, Ms. Lawrence Whitaker. And sorry for not introducing myself. I'm Elliot Schoen. I'm counsel to the board, and I'll just be moderating.
Thank you, Mr. Schoen.
Counsel for the local Board of Ed.
Good afternoon. My name is Claude Devassi Jones, and I represent the Howard County Board of Education. I'm private counsel that has been designated to handle this matter.
Good afternoon, Ms. DeBasti Jones. Now, this exceptions hearing is being conducted consistent with Comar 13A, 01, 05, 07F. Each side has 10 minutes for oral argument. Appellants, you may reserve time for rebuttal. Would you like to reserve any time for rebuttal?
We initially indicated, because we believe there were 4 appeals, so we would get 10 minutes per appeal, but we've got something back from Ms. LaFiandra this morning indicating that that wasn't going to be the case. So initially we indicated 10 minutes for rebuttal, but obviously if we did that, we'd have no argument under the circumstances. So I'll reserve 5 minutes for rebuttal.
Very good. So you will have 5 minutes. Ms. Lawrence Whitaker, you have the burden of proof, and you will go first. You have reserved 5 minutes for rebuttal, so you'll have 5 minutes to make your argument, and then the local board will have 10 minutes to make its argument, and then you will have your 5 minutes for rebuttal. You will be given a warning at the 1 minute mark. And Dr. Simpson, could you set your timer, please, to give a warning at 4 minutes and then stop the oral argument at 5 minutes, please?
Yes.
And Ms. Lawrence Whitaker, when the 5 minutes is called, you may finish your sentence, but please then stop speaking and mute your microphone. And Ms. Simpson, would you please, Dr. Simpson, would you please set your timer for 5 minutes?
Yes. And just for clarification, so the first alarm that you will hear is at the end, is your warning at the end of the first 4 minutes, and then you'll have 1 minute remaining.
Very good. Thank you.
Okay, Ms. Lawrence Whitaker, at your pleasure. You may begin.
Thank you. Well, I'll just start with thanking the board for hearing my client's pleas today. Obviously, I can only do so much in 10 minutes. I'm going to assume that all of you have read the exceptions and the attachments with regard to the, especially the transcripts. I think the first point I want to emphasize to the board is that there was an opinion recently before our hearings in this case, and it was an unusual case because it was at the kind of the beginning of the COVID crisis, and we were working all through this new Zoom thing that now we're all pretty good at a year later, but at the time it was very new to most of us, and you know that had its problems, to be frank with the board. I don't think anybody would be surprised by that, but we did persevere on. But most importantly, the case of Michael D. versus Anne Arundel County Board of Education, your opinion number 20-07 came out shortly after our first meeting with the ALJ, in this case, Judge Phillips. And at that point, there had been no answer whatsoever from the Howard County Board of Ed. There had been nothing to indicate that they had filed an appropriate motion with you, the Board of State Board of Education, or with the ALJ to extend their time frame to file an answer. And indeed, they didn't answer until another 15 days beyond that first meeting. Over our objections, which were preserved on the record, we filed a motion to dismiss, and we believe that or a motion for default, against the Board of Ed for their failure to plea. And we believe that the ALJ made a fundamental mistake by not following the precedent that had just been laid down in the Michael D. case. We pointed out in our exceptions, and I think hopefully that traditionally, if an appellant had failed to make their timeframes with regard to filing their appeal, there were very narrow circumstances where they would be allowed to continue with their appeal, but the overwhelming amount of opinions were that you missed your time frame. The Michael D. case was the first one that I saw that I could find in the law that kind of evened that out between the state and appellants, saying, hey, state, you're, in this case, a local Board of Ed was held to the same standard. So we're asking that the court overturn that decision and find that they were late in their pleadings. They didn't have a right to continue to plead, and that there should have been a default granted. If the default had been granted, of course, then it would have been a matter of a decision based upon what should be done, what would be the results to correct the issues. The next issue that I asked the court to take a close look at was that the ALJ erred in understanding what the faulty data issues were. We went back to the Dipty Shaw case, which happened to be a Howard County case as well from, I believe, the early 2000s, where this board and at the time made a determination that if large amounts of or significant amounts of data were faulty, then it could be indeed arbitrary under the standards under COMAR. In this case, we showed that there were very significant amounts of data that were brought up before the final vote that changed during the evening of the final vote, and yet no one wanted to sit down and make sure they were doing that they are actually doing what they said they were doing. The idea of the redistricting in Howard County from our board, obviously one of the ideas was to balance the capacities of our schools. The other major driving force was balancing issues of socioeconomic disparities in the schools. I'm sorry, does somebody ask me a question? Okay, in any case, this issue—
You have 1 minute remaining.
Thank you, Ms. Simpson. This issue was not fully, the ALJ did not understand, based on the evidence, that the board did not properly understand their own data, and that we showed that the data was something like 84% unreliable on the night that they voted, based on what they had been working on for months. It came out that they had had a moving target. So we think that we more than showed that the data was faulty, and that should have been overturned. The last issue was that I wanted to bring forth was the issue of the Open Meeting Act. The Open Meeting Act was blatant, and it was significant. It was significant because a vote that would have changed all of the votes, and we showed in the evidence very clearly, and had admissions from the people who worked on these votes for the school board, that if this particular vote failed for this particular elementary school, it was going to drag down the vast majority, if not the whole plan, going up through middle schools and high schools in Howard County, because of the way this very intricate plan is written and the way the votes are. We showed that one member was essentially bullied in the back room in an illegal open meeting. However, the ALJ only would hear evidence from that one member, who the evidence was that from written statements at the time was being screamed at, being yelled at. She was in tears. She came, and the video evidence, she came back onto the dais sobbing, or at least very crying in a hard manner, and she continued to cry as she reversed her vote. And she even said on the record, along the lines, if I don't do it, the whole plan falls apart. So it was another admission. The ALJ refused to allow us even to have the other witnesses testify as to what they saw and heard in that back room as to the Open Meetings Act violation and how it affected that particular person. Her one vote changed the whole redistricting, because she changed it back to what the people who were bullying her, Ms. Chaj and Ms. Mallow, wanted her to do. The ALJ refused us the ability to—
Excuse me, Mr. Schoen, the time has expired.
If I may finish my sentence.
Finish your sentence, please.
Thank you.
Yes.
She refused the appellants the ability to have those witnesses of the other board members, Ms. Delmont Small, Ms. Catronio, and I'm trying to remember if there was one other, that saw the bullying occurring, so that she would have objective evidence, not just the evidence of the person who ended up changing their vote that day. Thank you.
Thank you, Ms. Whitaker. Thank you very much. Ms. DeVestri-Jones, you have 10 minutes to make your argument.
Thank you.
When you're ready.
Thank you. Good afternoon, ladies and gentlemen of the board. I'd like to address each one of the points that the appellants have brought up regarding their exceptions to the decision of the ALJ regarding her decision to affirm the decision of the local board of the Howard County Board of Education in their redistricting. First, when it comes to the application of Michael D. versus Anne Arundel County Board of Education, the appellants want to use that as a basis for default in which the ALJ provided that that would be an extreme remedy and not what was contemplated by the rules. Secondly, as the ALJ pointed out and as was argued by the local board, is that this is an appeal of a redistricting, not an appeal of the record. That is important to distinguish between Michael D. and this matter. That is because it's distinguishable because the appeal for the redistricting is an appeal of a quasi-legislative decision of the county board, unlike a quasi-judicial decision, which is what was going on in Michael D. And that is why those appeals are dealt with on the record, which is the record that was before the local board. When it comes to redistricting, those matters are delegated to the Office of Administrative Hearing, at which point it is assigned to an administrative law judge who then takes down the evidentiary hearing and takes the matter under consideration under COMAR, under the Office of Administrative Hearing rules, and makes the decisions that they believe are appropriate because it's been delegated, and then send that back to you all so that you may consider and decide whether or not you would like to affirm the decision, adopt parts of it, or make any changes based on the evidence that has been provided at that time. Judge Phillips, in this particular matter, agreed with the county board in this particular case, finding that she was given the lawful authority to exercise her rights as the person who would, in fact, make the decisions in this redistricting. She was empowered to regulate the course of these matters by issuing the orders and by also trying to make sure there was procedural simplicity and being in charge with the administrative fairness in this matter. And so we would ask that, based on that you would continue to affirm the decision by ALJ Phillips back on October 14th, 2020, to allow the local board to continue in with the appeal and to provide the evidence and to actually have a hearing and to schedule that was within her power, and that there was no violation of COMAR 13A0105. Next, the appellants were stating that they were discussing the data. Specifically on the data, they're trying to state that there were substantial portions of the data that were used by the local board of education that was faulty and inaccurate. However, that was not the finding that was made by ALJ Phillips. In fact, she found that there were no inaccurate data, and that in fact that the appellants failed to show any inaccuracy. In fact, what was in fact provided was that simply that the data, the farm data, which is what was the concern by the appellants, was that it was calculated differently. It's calculated differently than the Maryland State Board of Education versus how they use the calculations for the Office of School Planning. The data in this particular case, which they asserted was not adequate enough time for them to consider, meaning the local board did not have enough time to consider any revised data calculations, is simply just that, an assertion by the appellants. No evidence was ever provided to show that the board themselves, when making their decision as to the redistricting, did not have sufficient time to consider any data that was provided to them by the Office of School Planning. In fact, no member of the board indicated after they had received the data and after they had an opportunity to review the data, question the Office of School Planning about the data, state that they did not have sufficient time in order to go forward, and therefore as a board voted to either delay or not use the data. In fact, what they did was move forward and began the final vote for the redistricting on November 21st, 2019. The board had an opportunity to review the revised numbers, and they did not request any additional time, and no member of the board, after reviewing the data, changed their position as to how that data affected their decision in making their ultimate decision as to the redistricting. Finally, as it comes to how that reliance using the DIPTA case, I think that the characterization of the data as fundamentally flawed is based on a lack of understanding and speculation by the appellants. As was presented to the administrative law judge, and as was decided by the administrative law judge, that the change or the revision that was made by the Office of School Planning was simply to neutralize mobility and pre-K so that the methodologies used by the superintendent's plan and the feasibility plan match the same type of methodology. Not that there was anything ever inaccurate. No evidence was ever presented by the appellants that the data was actually inaccurate or faulty in any way. They simply showed that the data methodology and calculations were done in a different manner, and that was accepted and was in fact stated by the Office of for School Planning. So there was no evidence that was ever provided to show there was any inaccuracy, just that it had been calculated differently. The appellants argued that the ALJ did not accept their argument as to how the farm participation data was faulty. However, they did not provide any evidence, and the burden was theirs in order to show that it was faulty, and simply putting on the testimony of one or two board members to say they didn't understand or they thought personally that they thought the data was inaccurate did not in fact show that the data was inaccurate and that they did not rely, that it was substantially inaccurate. And finally, as it comes to the Open Meetings Act, as far as the failure to allow the appellants to provide testimony of additional board members, the testimony by any other board member in that particular matter was irrelevant and contrary to the position stated in Bernstein versus Board of Education of Prince George's County, 245 Maryland 464. Specifically, in Bernstein, it states, sometimes the opinion of a board member or testimony of one of its members may show that its action was arbitrary or unlawful, but ordinarily, courts review the actions of the board, not its opinions. In light of the administrative law judge's opinion in her motion for summary decision, which were cross-summary decisions by appellants and by the local board, the testimony regarding the Open Meetings Act violation was limited to whether the violation impacted the redistricting process as to render it illegal under the appeals provisions. That could only elicit then testimony from board members who would in fact had a say as to how that would have impacted them. Knowing that the vote was not changed except for one board member, which was board member Coons, no testimony from any other board member would have elicited any testimony as to the impact that it had on them for the redistricting. The only impact it would have would be their subjective impressions or opinions of what they thought. And in fact, the ALJ permitted written statements by certain board members that had written notes or comments regarding what had happened in that 4-minute recess, and reviewed those and took that into consideration in making her decision. There was no probative value as to having those additional board members testify, and it did not substantially outweigh any danger of unfair prejudice to the appellants. The actions taken by individual board members after the recess only affected the one board member Coons, who in fact testified on behalf of the appellants as to how or if the actual recess affected her vote. In general, in conclusion, redistrictings are really difficult, as you all know. There can never be a perfect plan. The board for the Howard County did their best with what they had. I think that the ALJ took a lot of time in reviewing all the evidence, as you can see from opinion. In fact, reviewing and watching the countless hours of work sessions that were had by the Howard County Board of Education to look and to see and to hear what the board was going through and listening to everything that was happening. And I think that she was very thoughtful about that. And I think it's reflected in that opinion. And as such, we would ask that you continue to follow the proposed decision of the ALJ and affirm and uphold the local board for districting plan. Thank you.
Dr. Simpson, have you reset your timer?
Yes.
Okay. Ms. Whitaker, you now have 5 minutes for the final word.
Thank you. I'm going to go a little backwards there on her last points with regard to the issues of the Open Meetings Act. What the ALJ determined during the cross motions for summary judgment, or summary decision in this case, was essentially, yes, that, what impacted the redistricting voting was what was going to be important. We put on evidence that had the vote not changed, the impact would have been that the redistricting would have fallen apart and it would not have happened. So to suggest that the only person who could testify as to what happened back in that room credibly and legitimately is Ms. Coombs, who's the person who changed her vote, is almost absurd to me. The fact that there were several other witnesses who viewed what happened, heard what was said to Ms. Coombs, heard what she said back, and all of that should have been admitted, not just one single person who, has the most subjective view of the events, because she's the person who was the target of these other two board members. To suggest that the other members of the board who witnessed all of these events couldn't come in and explain them because their opinions about what happened don't matter. The fact is, no one was asking them what their opinions were going to be. The fact was that we were going, the thrust of the examination was to be what they saw, what they heard. No one was asking them what their opinion of what happened. So it's actually a highly prejudicial error to have not allowed us to call in those other board members who were in the room and heard the exchanges and saw what was happening. With regard to the data, respectfully, even Judge Phillips admits that Ms. Delmont Small and Ms. Catronio both stated that evening on November 21st, 2019, or excuse me, 2020. Was it 20 or 19? 19. I'm sorry, I'm losing years here. I apologize. It's my second hearing of the day. That they did not have enough time to absorb the new data. And just to be clear, in order to make a comparison between what the redistricting was going to accomplish and where they started, they had a data set as to what the farms rates were for each particular school, and then what they believed would be the farms rates after the redistricting changes. We were able to isolate for Judge Phillips, okay, there were a number of schools, I think it was 13 if I remember off the top of my head, where there were absolutely no changes in their polygons that were moving in or out of their attendance area. Their attendance area changed not one bit, yet their farms rates changed, sometimes 5 points or more. And throughout the redistricting, one of the things they were looking for was a change of 3 points or more. So when you have the same school with no changes now changing 5 points, that does show that the underlying data from which they are comparing their moves to is unreliable. And that was the point that Judge Phillips missed. It wasn't that they used different methods to get there. Yes, they used different methods throughout the process without ever telling the board they were doing that. The fact is, when the board found out the night of the vote, moments before they, less than an hour before they're going to vote, if I remember, it's less than a half hour before they were going to vote, that all of a sudden the base data set from which they were making their comparisons was now showing some very significantly different numbers. No one, other than Ms. Catronio and Ms. Delmont Small, questioned if that was going to be a big problem. It clearly is arbitrary not to take the time to look at it and make sure that we are actually making the right moves if our base data set changes. That's if you don't know that the base data set where you started is accurate, how can you know that your moves are doing what you want them to do? That was the point that Judge Phillips unfortunately missed. It is in the evidence, it's in our exceptions, and I ask that you look at it. Lastly, with the default, I will point out to the board this. Michael D., the case, made no distinction between what types of appeals. It simply said, the local board has the same responsibility as the appellants. They've got to plea on time. And I will note for the board that in this particular case, not only did the local board for Howard County Public Schools not plea on time, but they filed no record when they filed their answer. No record whatsoever. So all of the thousands of pages of documents were not filed until much later in the case. That severely prejudiced my clients. At the time when we brought this, we had 6 different appeals, I think 18 different clients involved. So it wasn't just, we decided to move forward on the exceptions on 4 of these cases. But the fact is that on all of our cases and all the rest of the appellants that we didn't represent, they did the same thing. They had a duty to get their, not only their answer in on time, but they had a duty to get the documents that were underlying it from the lower record from the redistricting in so that we, as the appellants, were not prejudiced in the amount of time. It's great that we got the documents eventually, but it's like having a fire hose thrown at you and having to absorb all of that. There's a matter of fundamental fairness and due process. And this is the due process that was set up by this board. And we are held to that due process. We're just asking that the local board, who has far more resources than my clients do, be held to the same due process rules. That's it. It's fundamental. So I thank you so much for listening to me today. And I look forward to your opinion here. And if anyone had a question, I'd be more than happy to answer it.
Board members, do you have any questions for the appellant? Board members, do you have any questions for the local Board of Education? Mr. Bartley?
Hi, this is Sean Bartley. Hi, Claude Devesty Jones. How are you?
Good, thanks, Mr. Bartley. Nice to see you.
Nice to see you. There was a reference to the change of the data that was used to come up with the determination of the redistricting. How close was that data change to the final vote of the Board of Education?
So the revised data that is referenced in the exceptions was provided to the board on the date that they did the vote. They had discussed it at the meeting before, which is about 4 days beforehand, and at which point they went back to look at it and to see what if anything could be done about it. After they did that, they did present it to the board, explain to them what they were isolating, which was based on neutralizing the mobility and the pre-kindergarten, which was not contemplated, as I stated, in the superintendent's and the feasibility study, but had been used throughout the work sessions that the board were working off of during the redistricting. After they gave that to the board asked questions of the Office of School Planning. They took a recess to digest it, and then they came back. There was more discussion about it. And in fact, there was, as I stated, a statement made by one of the board members asking, does this change anybody's decision as to their redistricting plan? Nobody made any comments regarding that during the hearing, and then the redistricting votes began. So the timing it was that day, the same day that they were doing the actual votes, that they had the opportunity to review and question.
So was there 24 hours given to review and question, or were there minutes?
Well, I mean, it's I guess you could say it's minutes, but they had the opportunity to look at it. They took a recess to review it. They asked questions. They were given an explanation as to why there was the revision, and then they moved forward with it. And they were asked, or like I said, one of the board members did ask, does this change your decision as to how they're moving forward on the redistricting? And none of the board members said that it did.
Was the discussion formal or informal, and was the public allowed to attend those discussions?
This was all public. This is part of the actual session on November 21st, 2019. So the entire process is on there, except for the recess where they went individually to sit down and digest the information that they had received. But all of the rest of this is on the record.
That during the recess, who was present during the recess when these things were discussed? Was it an executive session, or was it an informal recess where each individual person reviewed the data?
It was a formal recess where each person reviewed the data, but all the discussions that I referenced were in public. They were in front of the community, and they were discussed, and the individuals answering the questions were the Office of School Planning.
Thank you.
Okay, seeing no other questions, council, thank you so much. The board will take your comments into consideration as part of their deliberations.
Thank you.
Thank you. Have a good day.
Well, thank you very much. We appreciate that. I'm going to read the statement to allow us to go into executive session. Pursuant to Section 3-305B7 in the General Provisions Article of the Annotated Code of Maryland, the State Board will adjourn to executive session to discuss the following: to obtain legal advice, and that the meeting will adjourn from the executive session. May I have, the floor is now open for a motion.
I move that we adjourn to executive session.
Mr. Shield, and seconded. Who was second? I'm sorry. Okay, General Sumter. Seeing has been moved to second. Questions? Seeing no questions. Dr. Simpson, will you please take the roll? Thank you.
Mr. Bartley,
Present. Yes. Thanks.
Ms. Bates,
Yes.
Mr. DeShiel,
Yes.
Dr. Getty,
Yes.
Dr. Green,
Yes.
Ms. Howard,
Yes.
Dr. Lee,
Yes.
Ms. McCusker,
Yes.
Dr. Lily McCarthy,
Yes.
Ms. Morrow,
Yes.
General Sumter,
Yes.
Dr. Wilcox,
Yes.
Mr. Wu,
Yes.
President Crawford.
Yes.
The vote is complete.
Mr. Shaw.
The motion passed.
Okay, we'll now adjourn and move into executive session. Thank you. Thank you, members of the public. We appreciate it. Have a great day.